and welcome to Onoway, Alberta. This is a farming community. For those of you who are joining us online, we deliberately chose this venue because we're talking about land rights, and we want farmers to hear about land rights. As you're going to discover, things are happening that you're completely unaware of, involving land rights, involving our freedoms, involving ownership. And many of it will be shocking. You know, on the way driving out here, I was thinking, like, is anyone going to believe what the truth is? And yet, you know, you can go online, you can go to the World Health Organization and verify what I'm saying. City of Edmonton used to publish. You can use the Wayback Machine and see how they used to publish about 15-minute cities. And that these are like on international organizations and cities and provinces. It's not hidden, but you're not told about it. So it really is hidden. This is going to be, we're in the process of an attempted complete social change and overthrow of the Canada that we thought we had, where the government is completely adversarial to the way of life that we believed we would be passing on to our children and our grandchildren. And nobody knows about it. So here we are in Onoway, Alberta, with a panel that I've been excited about all week. Where do you get to hear Bruce Pardy and Leighton Grey in person speaking about land issues? It's absolutely fantastic. I'm honored to have them here. I get to introduce them. But we're going to be educating you about land ownership and land rights, and challenging what you believe to be true. And just understand that every population, every country, every polity has to have what are called political myths. So we're fed a belief system so that we can all function in predictable ways. And political myths aren't meant to be negative things. They actually enable us to all get along and know what to anticipate and how to structure our affairs. But then we're given different political myths when things need to be changed. And so the world you believed you lived in, first of all, it never existed. It was a political myth that was there to enable us to function, and we were in a nation building phase. They wanted us to build a nation, and those political myths served the building of a nation, but they're not real and they're not true. They're political myths, and you need to understand that. And other political myths are being imposed on us to enable us to basically get rid of property rights, to get rid of the small farmers. And you need to understand what they are, and just understand that they are political myths, they are belief systems being imposed on you, and you don't have to accept them. I mean, the real problem is Canadians, we obey. Like, that's the real problem. Oh, well, no, those are the rules. Well, I'm going to, all three of us are going to be explaining, they may not use the word constitutional crisis, but I'm now publicly saying we're in a full-blown constitutional crisis. And many of our legal principles, they're not true. And the fact that, a very small group of unelected judges over a period of years could be painting us into a box that will completely destroy this nation and way of life, we can just say, no, actually, we're not going to stay in that box. We're going to collectively just say we're in 2026. We're all together. There's 40 million of us here. How do we pursue the destiny that is set out before Canada, where we are a nation of refuge, where we are a land of freedom, where we experience absolute redemption to bless the rest of the world? That's what's before us. We don't have to say, oh, we're victims, and yeah, we can lose our land, we can lose our freedoms, we can lose our way of lives, we can basically pass on to our children a totalitarian hell. We could actually just say, no, actually, that's not how we're going to play this game. And so hopefully this will be the first part. We have to open our minds, so I ask everyone to have an open mind and just accept that maybe the world you were taught that existed, that you believed existed, that you expected, maybe is not completely true and correct. Now I have the honor, we're going to basically have Bruce and Leighton and myself kind of rotate and share a little bit, and then rotate again and share a little bit, and then have a question and answer panel, and then take some questions from the audience. But I have the honor of introducing these two guys, and I will caution Leighton. Teresa, had asked you to send your bio, and I never got it, so I just completely made it up, and it's going to be wonderful. No, I'm familiar with you, and I will honor you, but I'm just, letting you know I didn't get your bio. But we'll start with Bruce Pardy. So Bruce Pardy has flown in from Ontario for this event, and also, Leighton Grey. It's a good 5-6 hour drive, and he is a travel warrior. Like, he's invited to come to events like this, and he just says yes, because he wants to share. And Bruce, he loses 2 days of travel and says yes. So I want you to know that these gentlemen sacrifice. They're not getting paid for this. They sacrifice their time. They sacrifice now their Saturday to share with you. And they're sacrificing that because they actually understand that the message has to get out, that what they're sharing is of fundamental importance to the entire nation. And so I would invite you to share this. So it's going to be posted online. We will rebroadcast it again. But we need you to share. We need you to tell people. And I think Teresa will get on to that. But let me just introduce the two gentlemen that I'm just honored to be working with today. So Bruce Pardy, he is a professor of law at Queen's University. He is the executive director of the Rights Probe, which is a law and liberty think tank and a division of the Energy Probe Foundation, which is one of Canada's leading free market public policy research organizations. He has been a law professor for 33 years in New Zealand, in the United States, and in Canada. He practiced civil litigation in Toronto. He was an adjudicator and mediator on the Ontario Environmental Review Tribunal. He is a senior fellow at the Fraser Institute and the Macdonald-Laurier Institute. He has been a tireless voice, almost like a John the Baptist out in the wilderness, basically trying to speak truth and get attention to things. And I'm just proud and honored to be working with him today. Leighton Grey, it's funny, like all three of us have practiced law for about the same period of time, 32, 33 years. So Leighton Grey has been practicing law for 32 years. He also has a business administration degree in addition to his law degree, and he has a PhD in philosophy. And for those of you who watch Leighton's podcast, Grey Matter, which is just an absolutely fantastic podcast, and for those of you who listen to Leighton lecture, you can see that PhD in philosophy. And it's actually so important because we're manipulated and we structure our affairs based on legal philosophical principles. So unless we actually take a step back and look at those legal philosophical principles, we're going to be trapped because some of them are false and need to be changed. And Leighton is one of the leading lights in kind of having us look at our legal philosophical principles. He just has an incredible mind, a prolific writer and lecturer. He's also a qualified mediator and arbitrator. He was appointed King's Counsel, I believe the youngest King Counsel appointed in the province of Alberta. He's got a whole bunch of accolades. I'm just going to mention some. In 2013, he was given the Stars of Alberta Volunteer Award. In 2015, the Legal Aid Society Access to Justice Award. In 2019, the Alberta Civil Trial Lawyers Association Gary G. Biggs Justice and Humanitarian Award. And most lawyers don't get a single award, and I'm just outlining some of them. And then he has been named as one of the top 50 lawyers in Canada. Now, just to dispel the rumors, I don't think it's true that his mother chaired the selection committee. But no, I know it was a total joke, right? No, I mean, isn't that crazy? So we've got Leighton Grey, who's been named as one of the top 50 lawyers in Canada, and the reason is he's just been tirelessly out there, case after case after case, and taking cases that other lawyers wouldn't take. And that's an important thing to mention. There's a lot of busy lawyers out there. But, with the COVID experience and the like, and regardless of where you fall on the COVID conversation, the reality is there were very few lawyers that were willing to go to court, willing to go to tribunals, and speak about fundamental legal philosophical principles that were being challenged at that experience. And those, we need lawyers to raise those to protect all of us. So those are the two gentlemen I get the honor to working with today. My name's Shawn Buckley. I have a much smaller CV. I've been practicing law working on my 33rd year, and focused on constitutional law. And was a very high volume trial lawyer. I probably run about 1,500 trials. And now I'm trying to raise freedom issues and constitutional issues. When I get to speak, you'll learn that we are in a total constitutional crisis, and we actually need each one. We've gone from the point where you can just listen to things, and we've left the point where you can go, oh, well, others will take care of this. And I mean, here I'm at an event, and we've got Bruce Pardy and Leighton Grey and Mr. Buckley speaking about things, but our efforts are totally meaningless unless you actually start getting involved. And here's where it gets really fun. And again, it doesn't matter where you were on the COVID conversation, as many of us felt really challenged and afraid by what, I call the COVID experience. I mean, I remember here, I'm a constitutional lawyer, and again, it doesn't matter whether you supported or didn't support what was going on, I really saw state overreach, in my opinion, to the point where I'm believing I'm seeing a police state being imposed, and I still have that belief, and I couldn't believe what was happening, and I have to say I was very afraid. I was very afraid. After the COVID experience, especially in the province of Alberta, I used to ask the question, you'd be a typical audience, and I would say, okay, during the darkest time of COVID, did you honestly believe that the army would be used to go door to door, dragging unvaccinated people out of their homes and vaccinating them? And in the province of Alberta, when I would ask that question, after the COVID experience, well over half of the hands would go up, which means that well over half of the people that, at least I was interacting with at events, believed that the army would actually be going door to door and administrating involuntary medical interventions on people, which is pretty significant. And the level of fear was very high, and I was very afraid until the truckers. Well, I never stopped being afraid, but when the truckers rolled, I thought, okay, there's people standing up, so I have to do whatever I can. I love this country. I want it to pursue its destiny, which it's not. And I've come to understand that actually, if we all stand up, we can make this the freest, most prosperous nation on earth. What nation, you hear about Dubai having all this money. Well, wait a second, we've got more oil than them. We've got minerals. We've got fresh water. We've got timber. We've got agriculture. We've got a society that believes in freedom, which is necessary for prosperity. And we're educated. How can it be that we're in debt? How can it, Canada should be so rich that, grade 6 students should be coming home and asking their parents, the teacher was talking about something called poverty. None of us could understand. What is she talking about? That should be Canada. And yet, we're really the laughingstock of the world. I've heard person after person after person internationally that I'm talking to privately, and it's like, oh my gosh, you poor guys in Canada. Well, that's not our destiny. And every single one of us is here right now for a reason. So we can't be afraid anymore because you are designed specifically to be here at this time to do what God set out for you to do. It's called a destiny. The Bible tells us that he actually wrote a book about you. And before time began. And so if you think you're afraid, you think you can't do this, you're forgetting who you are. And you are the person that was specifically designed to be here at this time and face what you're facing. So, with that knowledge, I'm going to invite our first speaker, Bruce Pardy, up. And Bruce, welcome to This Is Our Land Forum. And as my wife Teresa would say, buckle up your seatbelts and grab the popcorn.
Thank you, Shawn. It's an honor to be here. I want to set things up a little bit. I want to talk to you about 5 concepts or principles about property. Some of this is the kind of stuff that first-year law students get in their first year at law school in their property course. But I want to set things up so that the information and the stories that Leighton and Shawn are going to tell you make sense in the context of the way our property law works, or the way it does not work. Let me start with this. Your property is an extension of your liberty. If you don't have property, then you don't have much. Imagine this. A monkey has a banana, holding it in his hands. That monkey needs to eat that banana as fast as he can. Why? Well, because if he doesn't, some bigger monkey is going to take it away. The monkey has a banana, but he does not have property. If he had property, he could take his time. First principle, property is a right. It is not a thing. Now, people think of property as though it is a thing. And that's understandable. That's the way we speak. That's the way I speak too. You say, I bought a property down by the river. Okay. People know what you mean. Or the car is my property. Sure, fine. But that's not actually the case. If we're going to be precise, let's try this. Your property are the legal rights you hold with respect to the thing. It is not the thing itself. So, if that's the case, then what is a right? Sometimes people think that the fact that they have property means that they can do things with the thing or the land. You own a piece of land. It's common to think, well, because I am the owner of the land, I am the one that can enter onto the land. I am the one that can go inside the house. And practically speaking, that makes a lot of sense, but it's not actually the case. It's actually the reverse. Let's try this. Let's say that nobody owns your land. There is no title to it. It's not you, it's not anybody else. Question. If nobody owns your land, then who can enter onto the land? And the answer, of course, is everybody can. So the fact that you have title to your land means not that you can go on, but that only you can go on. the effect of your property rights in your land is to control and limit the actions of other people. Your property rights are about other people. Your property rights mean that other people cannot trespass. Your property rights mean that other people cannot take your car, and so on, and so on, and so forth. Rights are the ability to limit the actions of other people with the help of a court. That's what they are. And if you go to a court and you ask for someone's actions to be stopped, like your claim that somebody is trespassing on your lawn, and the court says, well, no, actually not in this case, well then, the court's answer means that you do not actually have the right that you claimed. So, sometimes we think of property as a thing that you own. That is, if you have property, therefore you are the owner. That is often true, of course. If you have a house or a farm or a ranch and you're on the title, then you are the owner. Fine. But, of course, there are all different kinds of property rights in a thing. And many different people can hold different rights in the same thing or the same land at the same time. You may have a credit card on you. Here's mine. If you look on the back of the credit card, it may say something like this. This card is the property of the Canadian Imperial Bank of Commerce. It's my card. It has my name on it. But it's not. The bank owns the card. So, if someone were to take the card from me, and I were to object and say, that's my card, that person might respond, well, actually, no, it's not. I read the card. The bank owns the card, and therefore, your claim is no better than mine. Of course, that's not so. How can it not be so if it is the bank that owns the card? And the answer is because I may not be the owner, but I have a kind of property right in the card. I have the right of possession. I have a better right and claim to possession than the person who stole my card. And I would get the card back, assuming the law was applied in the correct way. Okay. Another example. Let's say you own a house and you rent it out. The person to whom you rent, your tenant, takes the keys and starts to live in the house. You are still the owner. But let's say that you drive past your house one day where the tenant lives, and your neighbor has parked their car in your driveway. And you think to yourself, I don't want the neighbor parking their car in my driveway. I've got to get it off. So you bring an action. You might not go so far as to bring an action, but let's say that you do. You get a lawyer, you bring an action, you say, my neighbor's parking their car on my property. Problem is this. You are the owner, but you have a tenant. There is a lease, and the lease has transferred a kind of property in the house. What is that transfer? You have transferred possession and occupation of the house. It is now your tenant with the right to exclude from that property. your neighbor, and, for that matter, you. You are still the owner, but the right to exclude at this moment rests with the tenants. Okay? So you can have multiple kinds of property interest in the same thing. Do not think of ownership as equivalent to property. The bank, of course, owns a property interest, holds a property interest in your land if you have given them a mortgage, a security interest. It doesn't mean they have possession. It doesn't mean they can sell the land. It is a kind of property interest. Number 4, property rights are said to be in rem. Not always, there are some exceptions, but for the most part, they are in rem, meaning applicable against all the world. If you have both ownership and title, possession and occupation of a piece of land, you have the right to exclude. You hold all the property rights and entitlements in that property at this moment. Those rights apply against everybody. But if you have a contract with someone, those rights are what they call in personam, meaning they apply against the person with whom you have the contract. Here's an example. Let's say you go to buy a bike. You find a bike you like, it's a used bike, and the person that has the bike who's willing to sell it to you, the two of you agree upon a price. Let's say it's $400. And you together agree that next Thursday you're going to come back and pay the $400 and you're going to get the bike. And you make it a contract. It's a binding contract today. So you're very happy about that, and you go away and wait until next Thursday. In the meantime, the person with the bike sells the bike to somebody else who comes in and says, I'll pay you $500 for that bike. They agree on it on the spot. The $500 is exchanged, the bike is taken away, and away it goes. And next Thursday, you go to pay your $400 to pick up the bike, and you're told, I'm sorry, the bike has been sold to somebody else. And you say, but I have a contract. And you do. But that does not get you the bike. Let's say you track down the person who bought it. And you say, I have a contract for the sale of that bike is mine, hand it over. They will say this, or they should. You may have a contract with the guy who had the bike, but that contract is good between you and him. I bought the bike is mine, I have the property interest, your contract does not bind me, please go away. And that is a good answer. So if you want your rights to apply against all the world, you want to have property. Contracts are good, but they only apply as of the people with whom you are contracting. And here's what I'm working my way towards. Here is the bitter truth about the way the law works in this country with respect to property. The state can take away, limit, encroach, curb your property rights in any way it wants, as long as it does it in the correct way. Now, how can this be? Because the whole idea of property, as I started off with, is that your property is part of your liberty. If you are a free person, then you are free to own things, and you are free to exclude others from that property. And those others should, of course, include the state. If somebody from the government comes up to your front door and demands to be let inside, you have the property rights to say no, and please get off my land. The problem is that there are becoming more and more exceptions to this idea that property is an encapsulation or a reflection of your liberty, and you have the power to tell the state to go away. I want to tell you two stories that will describe maybe in part how we got to this place where the state can take away your property in any way they want. Here's the first one. The first one is a little bit of history, just to give you context. Oh, that's a different view. I challenge anybody to be able to read that. It's a slide. Well, there we go. That's not quite the thing. Anyway, I skipped some. There we go. This is the story I want to tell you. In 1066 in England, this is, of course, a long time ago, 1066, a fellow named William the Conqueror, who was a Norman, came to England with his armies and defeated the Saxons and established over time a feudal society. And one of the main features of a feudal society is the system of land holding. Now, this is an oversimplified version, but it basically looks like a pyramid. The pyramid looks like this. At the top is the king, and the king holds all the territory. And if you are the king and you want to maintain your control over the land and the people, then this is one of the ways to do it. What you do is you take this territory over which you have control, and you don't give it away. You say, I am going to give you, a certain small number of people, the right to use this vast tract of land. Let's say you divide it up into these huge tracts of land, and to a very small number of people that you can control. And then those people in the second layer of this pyramid do the same thing. They take their own tract and they say, all right, all you other people, you can have this bit and this bit and this bit and this bit. And in exchange, all of the levels below owe the level above something. So this first level, these lords or barons, as you might like to call them, owe the king sometimes money, sometimes military service, sometimes food. There are all kinds of things that the level below owes the level above. So king to lords or barons, to knights, to finally the people who are actually working the land at the bottom, the serfs. Okay? Pay up, pay up, pay up, and finally to the top. None of these people in the pyramid, none of them in the pyramid actually purely own the land. It is all held by the king. Here's what's happened over time. The middle layers of this pyramid have disappeared, but the structure still remains. What you end up with is this. This is what we have today. The crown, in right of either the province or the country, holds all the land. And everybody who owns land, you probably own your land in fee simple. Fee simple is an estate. It's an estate in land. It is not the land itself. You own as of the Crown. Now, all of these particular service and supply requirements have disappeared, except the idea. And the idea still remains, which is, oh, you will pay property taxes. Well, because you're paying it to the level above you, and the level above you is the Crown. So that's the historical context that makes the way our land holding now make a little bit of sense, but perhaps even more importantly, here is the strict legal story about why it is the state today can take and curb, limit, encroach upon your property rights in any way they want. It goes like this. If I can go back to my legal pyramid. Sure thing. That's good. Let's go one more. Let's go there. Not going to worry about that. That's what I want. Here is a very simple representation of our legal system. This is the hierarchy of laws. At the top, as you probably know, is our Constitution, the supreme law of the country. In the middle are the laws created, enacted by legislatures, the statutes, along with the regulations that accompany them. And at the bottom is this thing called the common law. The common law built over a long period of time by courts. Laws of contract and property and torts and so on. Each level is superior and overrides the level below it. If the Constitution says it cannot be done, then the statute cannot require it. And if a statute says that the common law is changed, then the common law is changed. Constitution first, then statutes and regulations, and then the common law. Here's the thing, as you may know. In our Constitution, there are no rights to property. There is no property right. Not in the Charter, not in the BNA Act, not there. What does this mean? This means that legislatures, whether in the province or in Ottawa, Parliament, can legislate anything they want with respect to property. And occasionally they do. My next slide should be, well, let's just see if I can find the right one here. No, not yet. Not sure why that's so small. Anyway, here's a bit of context for this missing property right. I have to say I am no fan of Pierre Trudeau, but the missing property right in our charter is actually not his doing. He wrote a draft of what eventually became the Charter of Rights. And his original draft included property. But in the years between that and when the 1982 Constitution was enacted, including the Charter, that property guaranteed was taken out. And it was taken out at the behest of both the federal NDP party and a handful of the provinces, including Prince Edward Island, Saskatchewan, Quebec, and Alberta. Now, why did these provincial leaders not want property rights in the Constitution? Well, for various different reasons. Partly because they thought having a property right in the Constitution might interfere with their ability to do various kinds of things, like nationalize, or I guess properly said, provincialize certain industries, to expropriate property for provincial projects, and they were also concerned, in Alberta's case, with federal interference in provincial jurisdiction. But for whatever reason, it has been left out. And therefore, if you have a legislature determined to expropriate your property or to create requirements, regulations, licensing, inspections, they have the power to do that. We have expropriation statutes across the country in every province, and those statutes say the following thing. The provincial government has the power of eminent domain. Eminent domain means they are able to take title to your property away from you for the purpose of, say, a highway or a pipeline, and pay you market value in compensation. Now, that sounds not great, but it's not so bad because you get compensated. But that is because that's what the statute says. If they changed their minds, they could change the statute. They could change the statute in theory. They haven't. They haven't gone quite this far yet. But they could decide, if they wanted to change the statute to say, we're taking the title to your land and we're not going to pay you compensation. Now, that would be a very politically dangerous thing to do, but the point is, it would be a political restraint and not a legal one. Legally, no problem. I'm looking for a quote now. Let's see if I can find it. There we go. There we go. I just picked this out as an example. This is from a case a long time ago, but it encapsulates the idea. The legislature, within its jurisdiction, that means either provincial or federal, and by the way, it is primarily property. The subject of property in the law is primarily a provincial responsibility, provincial jurisdiction. Most of the interferences with your property are provincial, not federal. The legislature within its jurisdiction can do everything that is not naturally impossible and is restrained by no rule, human or divine. If the plaintiff had rights, the legislature had the power to take them away. The prohibition, thou shalt not steal, has no legal force upon the sovereign body. They can do anything they want. And here are the kinds of things they are doing. I'm just going to give you a taste. You're probably familiar with some of these. Leighton and Shawn are going to tell you stories that will get progressively worse. But let's just take a sample. Let me go back to that one. Here is Bill 22 of Alberta, which has now been introduced, not yet passed. This has been introduced by your own UCP government this spring. This is the statute that's going to amend the Animal Protection Act. That statute provides for the power of the government to send inspectors to any land, to enter onto any land where animals are kept, for no reason other than to inspect. Do not need a warrant, do not need reasonable or probable grounds. They can do it as of right because that's what the law says. Okay? Your land and your right to exclude from your land does not work in that circumstance. This is just one of a whole lot of examples where the government has legislated its own power to enter onto property to do whatever it thinks is needed. Second example. If I can get to that National Post headline. You may have heard this story. This is a family in Ontario. They bought a vacant lot upon which they wanted to build a house. The excavations were beginning. I think they were tearing down the garage. They found human remains. And being good citizens, they reported having found human remains. They turned out to be very old, probably an Indigenous site of some kind. The Ontario government has enacted legislation and regulations that require not only the construction to stop, but for essentially an archaeological dig to be performed at the expense of the owner of the property. It is obligatory. And in this case, it is estimated going to cost them more than $1 million. There is an equivalent provision in Alberta, just so you know. And there it is. That's the equivalent provision in Alberta. And maybe I'll end with this one. This is one of my favorite examples of the kinds of encroachments that are happening in Canada that Canadians are just sort of accepting. This is the empty home tax in place in Vancouver. There's also one in Toronto. This is the calculation of an empty home tax on a very ordinary family home in Vancouver. That home is worth about $1 million. The annual empty home tax, meaning you bought a house, you own the house, you're paying the mortgage, you're paying the property taxes, it's yours. If you decide not to be in your house for a certain number of days of the year, Vancouver and Toronto have decided they're going to penalize you for that decision that you have made about your land. And this is the Vancouver bill on a very ordinary $1 million house, $35,000 a year for not being there. This is the kind of era we've entered into. What is happening? Here's what's happening. We have entered into an era where governments no longer believe that your property and your lives are yours. They believe that their job is to manage things, to manage property, to manage commerce, to manage beliefs, to manage speech, to manage the decisions that you are making. And if you decide that you don't want to be in your house for a certain period of time, 6 months of the year, then they don't approve of that, and they're going to try and manage you differently and penalize you for that mistake. I saw a report recently, I think done by the Ontario government, that was taking, quote, an inventory of how many bedrooms, empty bedrooms there were in the province. Okay, get this. They think that the empty bedrooms that exist in the province is their inventory for them to decide what shall be done with them. It's a managerial state. And finally, I'll leave you with this. Here are just some, not even an exclusive list, some of the kinds of incursions that governments today in this country are placing upon the use of property. Now you'll note that expropriation is the very first one. And expropriation is the most extreme. It's an actual taking of title to your land. But in many cases, you might be better off if they actually did take your land because at least according to the statute that presently exists, you would at least get compensation for the taking. All the rest of them are incursions upon your property that you do not get compensated for. Regulations and taxes and quotas and inspections and, well, the list goes on. As I say, that is not an exhaustive list. Okay, so that is the context. We have now entered into a situation where, rather than your property, your land, your home being your castle, it is now considered to be a thing that you must use in a way that is consistent with your government's view of the common good. And the whole reason to have property rights in the first place is to enable you to push back against that notion. I'll leave it there and hand it over to Leighton. Thank you very much. I'll just let that.
Thanks, Bruce. Isn't he great? I think if we had more law professors like Bruce Pardy, we'd have a very different Canada. In fact, especially a very different set of lawyers in our country. I was actually a little bit relieved that when Bruce was referring to big monkeys, he didn't point to me. My father-in-law, Jack, who's here at the back of the room, his favorite nickname for me is Gorilla. I'm very grateful for the introduction that my good friend Shawn gave me. One thing I don't think he mentioned, though, that's very relevant to the topic I'm going to be presenting today, first of all, is that I have a card here. Bruce had a card, a credit card. I have one that might be more valuable. This is my Indian card. Yeah. Educated Indian, look out. So, and you know, actually, if you're interested, Shawn mentioned my podcast. I just published something on there for Father's Day that went into my history, of the Indigenous side of my family. If you want to check that out. But here's just the highlight, just so you know, I have some chops to talk about the subject I'm going to be getting into. So I trace my Indigenous heritage back to the generations of the Grey Eyes clan. This is a proud Nakota Assiniboine family from Carry the Kettle First Nation. This is part of Treaty Number 4 in Saskatchewan. And I'm told that actually some of my ancestors were at Little Bighorn when Custer made his famous last stand. My great-grandfather was chief. My great-uncle was also chief. In fact, my great-grandfather, not to boast, was actually a decorated World War I hero. He was a sapper. He was famously court-martialed, actually, for stopping during a march back from the front in Belgium because a Frenchwoman was having a baby in a ditch. And my great-grandfather and another fellow who was there, who also happened to be Indigenous, they were buddies, they stayed and helped her deliver the baby. So he was court-martialed, exonerated, and then he got an award for doing that later on. So it was an all's well that ends well story. He also was one of the first Indians in Canada to earn a bachelor's degree, which was something extraordinary if you think back to the, this is before 1920. Allegedly, he was an outstanding athlete, also would have qualified to go to the Olympics, but couldn't at that time. It goes on. My grandmother, who died in 2018 at the age of 98, well, she would have said she was not yet 25 because she was born on a leap year. But she and her sister spent most of their childhood at Indian residential school, Brandon Residential School, which is one of the ones that I guess is more notorious now for abuse. Interesting thing is, my grandmother doesn't remember any of that abuse going on. In fact, she said that she was very grateful for her time at residential school. She was trained to be a nurse. She worked in a veterans hospital afterwards and ended up meeting my grandfather. My father, my late father, Len, was very involved in, he was a former gang member, actually. It's a good story. My dad stole a car as a teenager, and someone else's car, Bruce, as Bruce was telling. In those days, we respected property rights, I guess. And he went to a place called Reform School, which they don't have anymore. And he was recruited into gangs, Indigenous gangs. And maybe many people don't realize this, but Indigenous gangs are very active in this country. And they're committing a lot of crime, everything from drugs to violence, robberies, human trafficking. And anyway, my dad he started something called Spirit Keeper Youth Society, or SKYS. And the goal of that operated sort of between the 2010s to about 2020. And what my father did is he started this organization. He would transition young people who were in gangs out, which, if you understand this world, is a very dangerous thing, okay? So there it is, and then you come down to me. And I've been very involved in representing Indigenous peoples in my work. I was actually at the table with former Supreme Court Justice Frank Iacobucci when the settlement deal was struck and the big Indigenous residential school, Indian residential schools class action was settled. And I represented hundreds of people in that process. So that's my history, a bit of my background. And why have I told you that? Well, because now I'm going to talk to you about something that I call Aboriginal entitlement. And Bruce gave a great explanation about property rights and how property rights in Canada are being eroded and in some cases destroyed by our legislatures. Meanwhile, our courts, our unappointed elites who are being selected by the executive branch of our government very carefully, they're busy creating new property rights for people who have cards like mine. So this is a shorter version of a piece, if you're interested, that's on my show, Grey Matter, shameless plug. And if you want to hear the whole thing, it's all there in audio or video version. So if you can't stand to look at this face, you can just listen to it. You know, the voice might grate on you, but it's not as bad. Well, so we start with this proposition, which I think is the truth because it's in a book that is the truth, and that is Psalm 24, verse 1. Anybody know this one? It says, "The earth is the Lord's and everything in it, the world and all who live in it." So that's who the earth belongs to. At least many of us believe that. But I want to talk to you tonight and speak plainly about an issue that many Canadians are only beginning to understand. And that is the relationship between Aboriginal title, private property that Bruce talked about, and the future of reconciliation in this country. And these things are being tied together in a very, I think, nefarious way. So this is not, some of the stuff I'm going to talk about is going to sound like legalese, but this is not an abstract legal debate I'm talking about. It goes to the heart of what ordinary Canadians like you and I believe we own and what governments are prepared to defend, and whether courts can reshape property rights without the public fully understanding what is at stake. So my purpose is to walk you through 3 points. The first one is how Canadian law arrived at the present moment, and Bruce did a good job of setting me up for that. Thank you, Bruce. Second, why a decision called the Cowichan decision in British Columbia matters so much. And thirdly, why land acknowledgements, as they are now commonly used, are not mere harmless ceremonial language, but part of a broader political and legal narrative that we must all absolutely, unequivocally, unapologetically reject. So, part one is how we got here. Okay, so to understand the present controversy, we have to begin with the legal foundations of property in Canada. In the main settler states founded by Britain, which would be the United States, Canada, Australia, and New Zealand, the courts have generally said that the Crown acquired the underlying title to lands occupied by Indigenous peoples. That's what Bruce talked about the Crown owning the land. But the source and meaning of that underlying title has never been entirely clear, especially in Canada. In the United States, Chief Justice Marshall had a famous decision in a case called Johnson versus McIntosh and Worcester. There won't be a quiz later, folks. You don't have to write this down. But the court wrestled with the so-called doctrine of discovery, sovereignty, and Indian title. In Canada, the Supreme Court has taken a different route. It is largely assumed that the common law doctrine of tenure came with British sovereignty and that the Crown therefore held underlying title to all the land, as Bruce has explained. Now, this point really matters because underlying title is not the same thing as an unlimited power of government. It is a property interest. And in the common law tradition, property rights are not supposed to be taken away by executive discretion. They can only be interfered with by clear law enacted by a legislature with constitutional authority. That's a serious problem too, but it's not the one I'm dealing with right now. So the Supreme Court of Canada confirmed important parts of this framework in a case called Delgamuckw from 1997. Say that 3 times really fast. But British Columbia, the BC government, argued that its underlying title allowed it to grant fee simple title to private owners in a way that effectively displaced Aboriginal title. So they were trying to assert this age-old doctrine that the Crown owns all the land. But, sorry, I'm having a technical difficulty here. So then what happened is the court rejected that view, and they said that the underlying title did not give the province a freestanding jurisdiction to extinguish Aboriginal title. Then in a case called Haida Nation versus BC, the Supreme Court said that provinces have a duty to consult where proposed government action may adversely affect asserted Aboriginal title. So again, the principle was clear provincial ownership of underlying title, that it does not by itself authorize infringement of Aboriginal title. So the court is creating this new thing out of the ether, this thing called Aboriginal title. You didn't vote for it, I didn't vote for it, my great-grandfather wouldn't have understood what it was, but the Supreme Court is creating these property rights, this new property right. And later, both in Delgamuckw and then later another case called Silcott Nation, the court also developed a broader conception of Aboriginal title. And this is really key. They said it's not merely a right to use land for traditional purposes, but a right to the land itself, including beneficial interests in resources. So you see they're expanding this concept of Aboriginal title. And this is a key turning point because once Aboriginal title is characterized as a full beneficial interest in land, the question becomes unavoidable. What happens when that title is declared over land already held in fee simple by private property owners? Enter Cowichan. Why does the Cowichan case matter? I know Shawn has written about this, and maybe he's going to talk to you about this too, but for me, this brings us to this case, this Cowichan case, and Justice Young's decision in August of last year caught many Canadians by surprise. And not because the legal issues were minor or insignificant, but because they're enormous. The case involved years of litigation, an exceptionally long trial, and claims that, if accepted, would have serious consequences for private property in British Columbia and indeed all of Canada. And in fact, arguably, the entire Western world. One striking feature of this case is that the affected private property owners were not formally notified in a way that allowed them to defend their own interests. Stop there for a second. Imagine This is a case that went on, or a trial that went on for about 8 years. You're a property owner. Potentially, your land is going to be impacted by this decision. Do you think you had a right to know that the case was going on? Nodding in the affirmative. Yes. And in fact, one of the principles of fundamental justice, that is, the procedure by which our law is governed, is that if you have a property right that's impacted in this way, if you have a legal right that's going to be impacted, you have the right to notice. You're entitled to be given notice. Well, why are you given notice? So that you can come before the court and present evidence, present facts, present law, defending your interests. Well, that was denied to all of these property owners, these private property owners. Question is, well, why? Well, the remarkable fact here is that the fee simple title is supposed to represent the strongest form of private ownership in Canadian law, right? And it has been for a long time. Aboriginal title is also described by the courts as exclusive and beneficial. But if both are said to exist over the same land, we're left with a practical contradiction. Do you see what I'm saying? So two exclusive interests cannot comfortably occupy the same space at the same time. A second reason the case did not attract public attention is that when requested to formally notify affected private property owners in the Richmond, BC area, the court actually declined to do so. Can you believe that? So lawyers actually came before the court and said, hey, we should really let these property owners know what's going on. And the court said, no, we can't do that. Had these private property owners been notified of the claims, and imagine you're one of them, if they had been informed of these claims being advanced by the Cowichan plaintiffs, the case would have garnered immediate, extensive media coverage. You see why the court didn't want to do it. And this is because Aboriginal title claims against private property are a flashpoint issue. And so news coverage of the decision was essentially very, very little. We didn't find out actually until the decision was released what was really going on. So the question here is not merely theoretical. Here's the question. Can the owner sell? Will the banks renew mortgages? What happens to future development? Who bears the cost of reconciliation if private property is impaired? Well, these aren't academic questions. They're household questions, especially to these Richmond property owners. And listen, if you've been to Richmond, this is not swampland. This is some of the choicest real estate in our entire country. It's beautiful out there. And so here, it's important to understand this is not just a BC problem because of the way it's unfolding. This decision is based upon interpretation of cases out of our Supreme Court of Canada, which apply all across Canada. So obviously, since the court refused to notify them, they were unaware that their fee simple titles would be seriously impaired by these declarations of Aboriginal title that were sought by the Cowichan plaintiffs. At least they didn't know until after the decision was released. The court's reason for refusing to notify these property owners of the case were threefold. Number one, that the Cowichan plaintiffs vigorously opposed notification, arguing that the courts had always declined to notify private property owners in Aboriginal title cases. Does this sound like a good reason to you? Yeah, I'm not sold on that one either. That in any event, the Cowichan plaintiffs were not seeking a declaration would affect the fee simple interests of the private property owners. I mean, come on, right? Thirdly, that not notifying the Richmond private property owners would foster reconciliation. Yes, groan. The private property owners were thus deliberately kept in the dark for over 8 years about the fact that their fee simple titles would be impacted. That is until they awoke on the 7th of August 2025 to learn that their fee simple titles had been affected in the most severe way possible by really a clandestine judicial decision. So, what does a declaration of Aboriginal title mean to private property owners anyway? This is maybe the question that you're asking. Well, the BC government has downplayed the impact of the court's declaration of Aboriginal title by emphasizing that the rules for filing in the BC Land Titles Office have not changed. Wow. That should give people so much confidence. However, the real issues are that, firstly, the court found that Aboriginal title exists over the lands of private owners. Okay, that's a pretty serious encroachment. Secondly, the private property owners' fee simple titles are not a justifiable infringement on the Cowichan Aboriginal title. Notice how they reversed that, okay? So what they did is they placed private property ownership below, in legal importance, the Aboriginal title, okay? That's key, which the court, this Aboriginal title, the court has now declared to exist over private property owners. And thirdly, although the court declared that Aboriginal title and fee simple title coexist over these properties, that is clearly unworkable since both types of ownership are exclusive in terms of the right to use and benefit from them. Bruce used the example of leasing. Well, can they both lease the same property? Clearly not. So exclusive ownership by two different entities cannot practically exist over the same land simultaneously. But the court did not address its mind at all to this problem. So can the private Richmond title holders still sell their properties? Will lenders renew their mortgages? Must they move? These questions and many more are now completely unresolved. The court's answer was to say that British Columbia has a duty to reconcile fee simple ownership with Cowichan Aboriginal title through negotiation. So this is a tactic, that oftentimes the conversation between legislatures and courts are like this. Court creates a hot potato and they say, here, legislature, you take it. And this is essentially what the court did. Well, it's not our problem. It wasn't before us. We didn't have to decide it. Okay, Mr. EB, you guys go figure this out. So that's what they said, negotiation. Aboriginal title through negotiation. But negotiation in this context likely means compensation. And compensation means taxpayers. Either Aboriginal title holders are compensated so private property owners can remain, or private owners are compensated because they're forced to give up their land. In either scenario, someone pays, and ordinary citizens deserve to know the size and the nature of that obligation, don't we? Okay, and this is why the Cowichan decision has implications beyond Richmond. Aboriginal title claims exist in many parts of British Columbia and elsewhere in Canada. In fact, about half of New Brunswick is now under these claims. Large parts of Ontario that are not covered under treaties are now in these claims. And I think it's only a matter of time until we see this come to our door in Alberta. So, if courts can declare Aboriginal title over private lands without the affected owners participating from the beginning, then I think Canadians need to have a national conversation about due process, about legislative responsibility, and the limits of judicially managed reconciliation. So, what does justice require? Well, in my view, the only just solution is for the appellate court in BC to order a new trial in which the affected private property owners are joined as parties. They should be allowed to defend their own interests. They should be permitted to test the evidence. They should not learn after the fact that their land has become the subject of declarations made in proceedings they did not meaningfully participate in. So what then is the solution? Well, the only just solution, given the fact that the court refused to notify these Richmond private property owners that their fee simple titles would be affected, is for the BC Court of Appeal to order a new trial. Another reason why there should be a new trial, and this is getting a little bit into the weeds of the case, but just an example of how incredibly bizarre these proceedings were. The court relied heavily upon the evidence of someone named Dr. Kenneth Brealey. The court found Brealey's evidence to be highly reliable, despite the fact that he could not testify or be cross-examined at trial because he was dead. He was diagnosed, sadly, with the terminal illness but underwent 13 days of pretrial deposition. That's where lawyers ask questions under oath. In 2019, before he died. Now, so a new trial would allow whatever expert witnesses the Cowichan plaintiffs put forward to be properly cross-examined. So again, this is part of due process, right? This is part of the way our justice system is designed, our legal system is designed to distill the truth and get at the truth. We get to test evidence through cross-examination. And when it's done properly, it is an incredibly succinct and precise way of getting at the truth. But these people didn't have the opportunity to do that. They were denied that. And, you know, I honestly, I don't know how, as someone who's run a lot of trials, maybe it's not as many as Shawn, but hundreds of, for example, sexual assault trials. I don't know how any court could find evidence to be highly reliable when the person given the evidence was not exposed to the test of cross-examination. Can you? I don't think so. Anyway, and this would also force governments to answer a question they have avoided, which is private property actually on the table as part of reconciliation? If it is, then we deserve honesty about that, don't we? We deserve to know what is being negotiated, what it will cost, and who will bear the burden. So what's the cost of the new entitlement? Well, this is what they say. They say we need to commit to serious negotiations that does in fact recognize the reality, the legal reality, the constitutional reality of Aboriginal title in British Columbia. The Richmond residents have been living on Aboriginal lands ever since they first purchased those properties, as did the previous owners. That's the reality that British Columbians refuse to accept. That's what the Cowichan plaintiffs are saying. So they're saying that what's private property rights, land ownership, is on the table for reconciliation. And this is really important. This is a slick little legal trick. So clearly for these chiefs, private property is on the table for reconciliation. Assembly of First Nations Grand Chief Cindy Woodhouse made a similar comment when she was first elected. Get this, she says, every piece of square inch in this country and across Turtle Island is Indian land. Wow. If private property actually is now on the table for reconciliation, then we taxpayers need to have that clearly spelled out for us by our governments, don't we? I mean, it's we who will have to pay the billions it will cost to compensate Indian bands for their Aboriginal title claims over private property throughout Canada. And it's private property owners who will suffer the incalculable damage that these declarations will cause. And you know, the financial context can't be ignored either. Federal spending on Indigenous programs has grown dramatically in recent years, and major class action settlements and land-related claims now involve tens of billions of dollars. Yet the public often receives little clear information about how these sums are determined, distributed, or administered. The Fraser Institute, of which our friend Professor Pardy is a senior fellow, is a really great public policy think tank, probably I think the best in Canada. In December of 2024, it published a piece called An Avalanche of Money, the federal government's policies towards First Nations. Now, it was not published as a commentary, but as a study. And to say that the findings are disturbing, I think puts it rather mildly. Between 2015 and 2025, note 2015 was when we got Justin Trudeau, the annual Indigenous budget nearly tripled from roughly $11 billion to more than $32 billion in 10 years. And despite this increase, look around, those of you who have been to a First Nations community lately. The lives and welfare of First Nations communities have not improved over that time frame. Class actions have been settled without litigation, estimated liabilities reaching $76 billion in 2023. Specific claims have been settled at a rate 4 times higher than by the previous Harper government. And even though tens of billions of taxpayer dollars are involved, we, the public, are being told nothing about when and to whom these class action payouts take place or how the trust funds resulting from specific claims are administered. First Nations have become more financially dependent upon government transfers, and this is important, far fewer of them are publishing audited statements. And we are now seeing the consequences of that lax enforcement. Tom Flanagan, who's a Canadian scholar and former expert witness in Aboriginal and treaty land claims litigation, he's argued that federal spending on Indigenous peoples now actually exceeds spending on national defense. Think about that. What is the first job of our federal government? Protect our borders. That's all of us. That's all 40 million of us, even the ones who maybe shouldn't be here. That's a different topic. You know, but we're spending more money on a fraction, less than 3% of the population. In Alberta, for example, you put this in the context of the recent decision concerning our independence petition, only about 1% of all the people in Alberta are First Nations people, and only 47% of them live on reserve. And yet, a few chiefs, after visiting with our king, can bring a court application and stop a petition that roughly 700, well, you know, stop a referendum question that roughly 700,000 Albertans want. Pretty scary, huh? So, I think the idea of spending that much money, like, it beggars belief. I'm sure some of you hearing that are shocked. You know, I'm just going to close off here. The late Carl Sagan, you know, if you know Carl Sagan, was an American astronomer who popularized science for the masses. And he was a 1978 Pulitzer Prize winning book that he wrote was called The Dragons of Eden, Speculations on the Evolution of Human Intelligence. And he wrote, "When we abandon the hunter-gatherer life, we abandon the childhood of our species. You cannot convince a believer of anything, for their belief is not based on evidence, it's based on a deep-seated need to believe." And I think that entire rationale is what's behind Aboriginal title. And you know, this brings me lastly to land acknowledgements and why they're bad. You know, over the past decade or so, we've been getting more and more of these land acknowledgements. And I'm going to use something that Bruce said to sort of give you by way of analogy. This is how, as an Indigenous person, how I see land acknowledgements. Okay, so Bruce says, you know, your car, that's a piece of property, or at least it represents a property right. Well, imagine that Bruce is my neighbor, and I have a shiny red Ferrari. Okay, and Bruce loves that car. Oh, he wants to drive that baby. You know, he used to watch Magnum PI when he was a kid, and right? He loves that car. And so what happens is, you know, he gets the keys. And so what happens is every day, he lives next door, the car's in my driveway, he goes to get into the Ferrari. All my neighbors on the street, all of our neighbors on the street come out to watch this happen. They're all standing on the front porch. And before Bruce drives away in my Ferrari, he tinkles the keys, he gets in and vroom, he says, "This is Leighton's Ferrari. I acknowledge that this is Leighton's Ferrari." Day after day, he drives the Ferrari away. I never get to touch the Ferrari. I don't even get to sit in it. Yeah, Bruce won't even take me for coffee. He can't stand me. But this is what these land acknowledgements are like. For most of the people I know who are First Nations people hate them because it just gets people riled up. And really, they're just so dumb. But why do we have these land acknowledgements? Why do we have them? Well, do you see the connection between telling people who own property and land, telling them that they're colonizers, that they're criminals, that they're exploiters, that they're imperialists, that they're genocidal maniacs, that guilt trip? You see the connection between that and the Cowichan decision, where we say, okay, private property owners, actually, it's not your land. It was never your land. We're going to give it to somebody else. Here's the key to the Ferrari. So you see, that's the connection. And this is the connection between land acknowledgements and Aboriginal title. It's a prelude to a kiss. It's a setup. So don't buy into it. Anyway, I just want to leave you with a little quotation, some fun facts about stolen tribal land. In the United States, the Sioux, who are my people, took the land from the Cheyenne, who took it from the Kiowa, who took it from the Pawnee, who took it from the Crow, who took it from the Arikara. The victors not only took the land, they enslaved their enemies. Okay? So that's how the indigenous people operated according to the law of conquest, right? That's the truth. That's why whenever you do a land acknowledgement, you have to acknowledge about 15 different First Nations, because it changed hands so many times. Anyway, thank you very much. It's been a joy talking with you. I look forward to talking with you a little bit later. And now I get to introduce Mr. Buckley, star of our show.
Thanks, Leighton. Thanks. Yeah, it's just an honor to follow Leighton and Bruce. So we have some philosophical problems. So the last thing Leighton was talking about was he was kind of listing how one nation conquered another nation, conquered another nation, conquered another nation. So let's say, we overlay Aboriginal title over all of Canada, so we basically lose property rights. Let's say we pay gobs of compensation, and then, archaeologists discover that there was another nation here before the Aboriginals. Do they have to pay it all back? Do they have to transfer property to a previous group? Should, bands that are, conquered from another band, should they really, no, yeah, you were on there when the Europeans arrived, but the principle that those that had the land before they were conquered applies. Like it's very interesting. This month, we're in June 2026 in Canada, there were a whole bunch of babies born. Babies of different races. Now, should those babies be treated differently based on their race? It's a really good question, you see, because I was taught that racism was where you basically disadvantage somebody based on race, or you privilege somebody else based on race. I was taught that that was racism, that all races should be treated equally. So, but it's interesting, I first came across this because I'm in my 7th generation and we didn't have this. But in 1990 I went to law school at the University of Victoria, and the first 2 or 3 weeks was something called legal process, which was my first time that critical race theory touched me. And so for 3 weeks, all of the law students had to go through critical race theory. And for the very first time, I've never encountered this before, so everyone has to forgive me for not assuming the guilt beforehand. But I actually learned that as a white Anglo-Saxon male, ignore that my family on my mother's side was pure Ukrainian, had nothing to do with the British Empire or colonization or anything. They were actually fleeing turmoil in Austria-Hungary, literally fleeing turmoil. So, and my father's side was, Irish, that, we're fleeing the, famine, had nothing to do with, the UK and the king conquering land or anything like that. So, but I learned that as a white Anglo-Saxon that I was personally responsible for actually things that happened before I was born. Now, I didn't believe in reincarnation before then. So, but literally the whole premise is because of my skin color, not even because of that I'm not, Ukrainian, stuff like that, because of my skin color, that I bore and my children bore a personal debt to people with a different skin color. And that's the basis of what we're talking about. And we can agree with that, or we can disagree with that. But why is it that nobody's actually going, remember, legal philosophical assumptions? So we are assuming from a legal philosophical perspective that children in Canada born today will have different property rights based on the race that they happen to be born in. So if you're born in one race, you're going to have this privileged property rights, even though you're a minority. I mean, I think Leighton's statistics are, so even if you include, the Métis in that, what we would call Indians under Section 35 of the Constitution Act of 1982 would be about 5% of the population. Like even if you include Métis, which is interesting, right? So, why can't the Ukrainian and Irish have special property rights? Like when those two disadvantaged groups get together. Like when my grandfather went to law school, I think he graduated in 1914, he couldn't eat with the other students because he wasn't United Kingdom, he was Ukrainian. Of course he couldn't eat with the other students. He was a Slav. He was Slavic. How dare he even think he could eat lunch with the British United Kingdom students? So why don't the Ukrainians get special privilege in Canada? Why don't we create a constitutional category for them? So let's talk about what's happening, and it's very frightening, but I just want us to start thinking about, we're institutionalizing racism, and we're not, the destiny of Canada being the most prosperous and free nation in the world is not going to be accomplished by actually institutionalizing racism forever, right? So the first premise is that people of a certain race born today, that we didn't persecute them, they didn't exist. But they get special property rights and special privileges because of things that happened hundreds of years before they were born. And other children, based on their race, based on their skin color, owe a debt to other races based on things that happened hundreds of years before that they had nothing to do about. That's what we're doing. So let's just call it. We can support that. Like if there are historical wrongs, well, those people are dead. Do we understand that? And the people that perpetrated, I mean, if we accept their historical wrongs, history is very nuanced. And we have been fed a political myth that United Kingdom Anglo-Saxons, and then by definition, by guilty by association, anyone with white skin, owe a historical debt to people that they've couldn't have ever met or ever participated in because they're separated by, in some cases, centuries. That's the legal philosophical assumption that we're assuming. And we're in the process of creating two types of property rights that are absolutely going to destroy us. So let's talk about that. So first of all, how many people in this room, because I know it's going to be an educated group, know about the United Nations Declaration of Indigenous Rights? Okay. So a little less than half of this room, and this is an educated room. You know that your neighbors will have never heard of this before. So Canada signed a treaty meant to permanently institutionalize racial property ownership in Canada. So under the UNDRIP Treaty, and I'm going to read to you parts of Article 26. So we have a treaty obligation. And it's stronger if I read it rather than if I tell you what it says. So Canada signed on to this treaty, Article 26, Subclause 1, Indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. So basically all of populated Canada, right? So it says they have the right to these lands. Well, Article 26, Subclause 2, let's drill down to see, well, what does this right mean? Indigenous people have the right to own, use, develop, and control those lands. Let me just say that again. The right to own, use, develop, and control those lands. So basically all of occupied Canada, the federal government has signed on to an internationally binding treaty to transfer ownership of basically all of occupied Canada to a very small group of people based on race. That's interesting, isn't it? But we had such a big public debate about it, and we voted about it, and we all supported it, so we shouldn't be surprised. Now, this is transformative. You know, when Leighton is talking about Aboriginal title, I mean, the court is saying, the court decisions, and it's all judge-made law. The courts are saying, you know, Aboriginal title can't be alienated except to the king. So here we've got, you know, Leighton's talking about the Cowichan decision. I mean, the city of Richmond, when you fly into Greater Vancouver, the airport's in Richmond, so almost everyone here has been there. So the city of Richmond, you wake up one morning and you learn that actually Aboriginal title has been overlaid and is superior to your title. Now, okay, so I live in Richmond. I've, you know, worked 35, 40 years. You know, I had an extra job to pay off my mortgage. I'm like one of those few people. I got no debt. I owned my house until this decision. Well, no worries. I'll just go to the Cowichan Band and I'll take out another mortgage for $1 million. That's what my house is worth, and I'll buy it from them. No, they can't sell it to you. They can't alienate it. It's permanent. It's a permanent communal property ownership. So once they have it, it's forever. Forever we're institutionalizing different property rights based on race. Can I say that again? So once it happens, it's a permanent institutionalization of different property rights within Canada based on race. So we have the Cowichan decision, where the court basically says, no, actually the Cowichan Band has Aboriginal title over Richmond. That's what they were asking for. And people in Alberta will go, well, that's fine. It's, you know, that's unceded property, but we're here where I'm standing, Treaty 6. We're okay, right? Except that the next argument in courts, and aside from this UN treaty, which has nothing to do with property rights. So I'll just segue back to that for a second. So this United Nations Declaration on the Rights of Indigenous People doesn't distinguish between ceded and unceded land. All of the land traditionally used, occupied by Indigenous people is to be transferred. Well, thank goodness, it's a binding treaty. Thank goodness it's not like law in Canada that the federal government's actually obligated to transfer all of occupied Canada to a very small minority based on race. Thank goodness. Oh, wait a second. In 2021, the Parliament of Canada passed the United Nations Declaration on the Rights of Indigenous People Act. And they append this treaty as an annex to the Act, and it obligates the Parliament of Canada to fully implement the Act, including the transfer of all of occupied Canada to a small group of people based on race. Did you know that? That they actually, Parliament passed an act obligating the Government of Canada to transfer all of occupied Canada, including your land, to Indigenous people with the right to own your land, use your land, develop your land, and control your land. Is there any ambiguity here? Because, you know, I'm a lawyer. I'm trained to look for ambiguity. I'm not seeing it. So your federal government has obligated itself to basically transfer all of occupied Canada, for all intents and purposes, to a small group of people based on race. Now, whether or not there are historical wrongs, right? I'm not here to argue that or debate that. I mean, there have been some severe problems with what happened in the past. But whether or not they're historical wrongs, regardless of what they really are, is that how we solve things here? You see, this is 2026. And there's 40 million of us from all around the world. And we're in a constitutional crisis. This is part of the constitutional crisis. We're in a constitutional crisis. And the issue is how do we build the most prosperous, free nation going forward? And it's not by institutionalizing property rights based on racism. It's not. If any other country came to us and said, you know what? We want to become prosperous. We want to become free. There's a minority of people, like 5% of a different racial group. We're thinking of giving them superior property rights over everyone else, so that basically there isn't ownership the way you and I think of ownership. And we think that's going to make us a prosperous, free, and fair nation. Like, we'd go like, what are you talking about? What drugs are you on? Like, it makes zero sense at all, except that's where we are. So we've got the federal government, by signing a treaty and then actually passing a law, saying we have to do this treaty. I mean, how many of you have heard of the Musqueam Agreement? Well, very few. So the federal government is in the process of a series of agreements with the Musqueam Nation. And I don't know, Leighton, help me out. Is there even 1,000 members of this band? No, so there's less than 1,000 people. And Leighton's saying it's probably not even a real band. But let's say it's a real band. So, so less than 1,000 people that are basically the federal government is negotiating to give them Aboriginal title and control over land over most of Greater Vancouver. And you haven't read the agreement because they announced it, but they won't share it. Now, I expect it's a preliminary agreement because they're doing things in steps, right? And they won't go any politically further than they can. But the trap is to basically move us into a communist nation, right? Because if you want to become a totalitarian state, aside from, the censorship and total administrative control and people learning, you train them that they actually don't have the right to do anything without state permission, which is we're all going into. But you have to destroy property ownership because that gives people power to resist. So, but they're not going to pass a law. Like in most communist states, they just pass a law abolishing private property ownership of land. Well, in Canada, they've come up with this more creative way. No, let's overlay property with Aboriginal title, which is communal. Well, and they can't manage it. It's a small group of people, so the state, the king, will manage it. Because the king's kind of like this, in George Orwell, there's Big Brother. Well, the king's kind of the big father. Because what the courts have said, and it's very paternalistic, is, yeah, there's Aboriginal title. That wasn't extinguished from the king coming in. But the king owns all the land. So the king owns all the land. The king has what's called the allodial ownership. Bruce has made it very clear we've inherited a feudal system. Under the feudal system, the king is called the allodial owner, which means there's no superior landlord to the king, which means the king is the owner of the land, as you or I would consider ownership. And then the king grants rights to the king's land. So under our court system, and Leighton's made it very clear, like this is all kind of nefarious and fuzzy, but under our court system, the king owns all the land in Canada, but there's this unextinguished Aboriginal title. And so the king kind of acts as the beloved, he's the owner, but he's kind of the father figure for the Aboriginal groups to kind of shepherd them because they don't have individual ownership. So the Cowichan band, they're not going to divide Richmond and say, okay, we've got, 2,000 band members, so let's divide Richmond up by 2,000. And no, they can't. It's not individual, it's this collective right. So the sad part for the Indigenous is, when all of Canada has just got this collective ownership, Aboriginal ownership, they don't get the benefit of individual ownership. We're all in a communist system where none of us really has control over property, but Big Father, the king, and when I come back to lecture again, I'm going to talk about how, our Constitution, it's not a Constitution and the king's in absolute control, but right now we're just talking about Aboriginal titles. So according to the courts, the king owns, but the king's kind of like this father figure shepherd that has to, very paternalistic, gets to protect the Aboriginals, which is racist. And they don't actually get individual ownership. It's this collective ownership. So we're going to give this collective ownership over the whole nation, both by court decisions and by treaty, over Aboriginal groups, and then we will not have any real ownership over our land. So that's where we're going. Has any of you heard of the Wolastoqey decisions in New Brunswick? The media actually falsely reported, oh, don't worry. The Supreme Court of Canada decided not to hear the Wolastoqey, appeal on a procedural issue. So in New Brunswick, there is a very small group of people that are, we'll call Wolastoqey, who are applying for Aboriginal title over half of the province of New Brunswick. And this half of the province of New Brunswick has hundreds of thousands of fee simple titles. And the issue is not whether or not they have Aboriginal title. The issue isn't whether if they get Aboriginal title, that's going to be superior over fee simple. The only issue is should private landowners be told or have the ability to attend and defend what they think are their property rights. That's the only issue at play. And the lower court said, no, they don't have the right to be parties. If, the court says there is Aboriginal titles, then the responsibility is on the Crown to basically negotiate to whether there would be any compensation to the fee simple landowners that have lost title to their land. And so that was appealed, and the New Brunswick Court of Appeal said, no, you actually have to give them the right to be able to attend in court. And then the Supreme Court of Canada said, yeah, we're not going to hear this appeal. Like, we're fine with what the Court of Appeal has said. There hasn't even been statements of defense filed yet. And yet the media was reporting, for BC and the rest of us, oh, don't worry, the Supreme Court's not hearing it. It solved the Cowichan decision. And yet both levels of court are absolutely clear that, the Crown has an obligation to basically negotiate, Aboriginal title, and that it's real, it can't be alienated. And so basically what the bands have to do is show that they traditionally used and occupied the lands, and they're going to get a grant of Aboriginal title. So let's talk about the legal basis about this, because it's so convincing. It's so convincing on how the king came to own the land. Like, you really can't dispute it. So in very simple terms, what happened was long ago a wooden sailing ship flying the Union Jack arrived on the East Coast. And they started to settle, and they planted the Union Jack flag. And so the king or queen, was queen back then? No, it was the king, it doesn't matter. The king or queen owns all the land. Well, that makes sense. I mean, if that's not a solid legal foundation, I don't know what is. And I think what we need to do is just have some other nation sail the ship over. I say let's get a wooden ship because it's more dramatic. Sails and the whole thing. Have them sail to the east or west coast. Find some place where there is nobody, build a little settlement and plant the flag. And then we can deal with them instead of the British Crown because they'll own all the land, right? This is very convincing. But really, that's what happened. So, we started to settle. And we've just assumed that this feudal system that began with William the Conqueror in 1066 somehow applies to us because we're told it applies to us. And then we've had some obscure court decisions, some time ago, not anticipating at all that this would be used as a weapon to destroy Canada, where, oh yeah, there's Aboriginal title. It can't be extinguished. And it can't be alienated to anyone but the Crown. And now the courts are saying it involves the right to use, occupy, use, and develop. And we've got treaty obligations. Well, can't we just say, because we've got a couple of options here. We can say, oh yeah, we're in this box, we're in this trap, there's nothing we can do. The federal government has the full right, and the courts, these appointed individuals, appointed by the Prime Minister, the federal government, that has this agenda. It has this agenda to move us into a communist state. I'm convinced of it. So we could just say, oh yeah, no, you have the legal rights to do this. We've got the courts, blah, blah, blah. Let's just accept it. Let's roll over. This is a rural audience. It's all published. Go to World Health Organization, One Health, dig into their climate documents, go to the city of Edmonton. You might have to use the Wayback Machine to see what they're saying a couple of years ago about 15-minute cities. But the goal is to get us off the land, to get rid of rural people, move you into the city. I live in St. Albert, and they're building all these gross apartment blocks all tight together. And it's like, okay, the people that already live in the city, they already have places. Who are these for? Well, obviously it's for the rural people when we move them off the property. Because, they're published about this. They want to get you off the property, off your land, and into the 15-minute cities that will actually, the roads will be blocked off and you can't drive. They're called 15-minute cities because you can walk a mile in 15 minutes, and there will be services, everything that you need, within 15 minutes. This is all public. Go to World Health Organization and search One Health. You'll see all of this. And City of Edmonton used to be proudly publishing until people were criticizing. Yeah, we're a 15-minute city. We're preparing for this. So, all of this is planned. So anyway, back to the Wolostok. And it's going to happen place and place and place. And if you think, oh, well, we're on Treaty 6. Well, you know what the argument's going to be in court is well, these are invalid treaties. And the argument's actually a pretty good one. If you were the judge, you might accept this because it's a reasonable argument. So, first of all, did those chiefs that were traveling, did they even understand property ownership? Did they even understand that basically the Crown was asking them to cede what we understand to be ownership from their people to the Crown? Did the people that, the chiefs represent, did they understand these concepts? Because you can't enter into an agreement if you don't even understand the concepts and what you're agreeing to. Right? Like I picked up, I will pick up hitchhikers. And I remember, about 15 years ago picking up, it ended up I knew the guy, in the rural of BC, and he was he would say, I'm of the Cowichan Nation, or not Cowichan, the Chilcotin Nation. And, we're chatting, really nice fellow. I'd known him for some time. And he didn't understand the concept of mortgage. He was trying, he wanted me to try and explain it to him. And he didn't, he didn't even have the conception of mortgage, right? So how could he even enter into a mortgage without even understanding the conception? And my point is there's a very cogent argument that the treaties that were made weren't real. And we would play the trick, the chiefs would travel, and then we wouldn't feed them for a couple of days, and then we'd feed them, and then, there's this kind of cultural reciprocity where they're indebted to us for the hospitality. And then we very quickly negotiate really sweeping things that any rational people would, you need independent legal advice on that, you need time to reflect, and you need time to consult. Like, could you imagine? Well, our government, I guess, they've signed a treaty without any consultation. And they, sure, passed Parliament, but nobody knew what they were doing. And do we accept this? Like, we're going to give up our way of life? We're going to give up our prosperity? We're going to become a totalitarian nation just because a small group of people are claiming they have the right to do this to us? Well, that's our I mean, everything's got to be peaceful, right? Like I challenge everyone to watch the movie Gandhi again, because it so strongly shows both the cost of peaceful civil disobedience, because that's the only way to do things, is just not buy in anymore. But there's a cost. And it really shows the cost, but it also shows the power. And the reality is, and I'll stop and we'll have Leighton come back and then Bruce come back, and then I'm going to do the constitutional stuff later. But it's so important for you to understand that two mechanisms are being used to basically overlay Aboriginal title onto your land, on, rural, urban, the whole thing, to basically completely undermine our society, which is based on private property rights. And it's how they're going to move us into a communist system so that we're completely dependent upon the government. And we have a choice. We can actually say, I get this whole thing was kind of a historical accident, and I accept these, few decisions by a handful of judges appointed. And we'll totally give up our way of life. We know from history that communist societies without land ownership lead to total oppression and poverty and starvation and that. But hey, communism didn't work anywhere else. There's no reason it can't not work here too. So we can do that. We can do that. Or we can say it's 2026. There's 40 million of us from around the world. And how do we together build the freest, most prosperous nation, which is our destiny? I'm tired of Canadians, it's Canada and they're enslaving us. Our destiny is to be a nation of refuge. Our destiny is to be a land of freedom. Our destiny is to be a land of redemption. We're to be a blessing to the entire world. That's our destiny, and I would rather claim that. And that's part of it's saying, acknowledging we're in a constitutional crisis. Our government is no longer acting for our benefit. And we are going to peacefully decide how should we restructure going forward to build the most free, prosperous nation that is a blessing to the rest of the world. So that we basically have two choices before us, but we really don't have a choice, because our destiny is to become a free and prosperous nation. So with that, I will hand off again. I think we're going to Leighton again, right? So, and while we're waiting for Leighton, we've got a sizable audience online, and we want everyone to subscribe to NHPPA.org. So go to our website, NHPPA.org. We're kind of unique as a nonprofit that is protecting our health rights and also bringing issues like this to your attention, and also help support events like this. So we put these events on, we absorb the cost, and we just trust that the public will donate so that we can cover our costs and keep doing stuff like this.